Trevino. Got it.
Travico, good morning.
Judge? So the staff, jail staff is right in the process right now of getting the two defendants.
Who do you want to proceed with first? Or,
It depends who they bring. Let me see if I can get the sound up here a little bit. It's really low. Sounds up. Okay. Are the failures to comply, are those done? Oh,
we have one waiting in the courtroom, just showed up, but the other two stricken, full compliance.
okay. Oh, great, great. I'll ask I think it's Officer Cook now, who's apparently kind of the full-time assigned court custody person. I'm gonna ask her if she can somehow figure out a way to get the volume up a little more on this end. I can hear you, but it's a bit faint.
Does this help at all?
It does.
Okay, yeah. I'll speak more directly into the microphone.
I think I've got the volume turned up on 100 here, 100%. Unless there's another spot.
Yeah. Sorry. So far, so good. Down to a slightly unresolved call and a slight reduction in the
Hey guys, how you doing, Mr. You're Mr. Dorsey.
Okay, Dorsey, have a seat.
Dorsey, yeah. Is there any way the volume? I looked at the controller, it says 100%, but it's just really low. He's trying to speak up. Unless there's like another. Oh.
Well, the volume is not working right now, sir.
working on the focus too. We're doing an online hearing from the jail.
See if I can get another pair of
Seeing if you get another pair of speakers if you're having problems with the volume.
Are there speakers connected to the computer? The little black ones. What do you mean? Okay, so, yeah. That's right.
Yes. In the staging. Pretty small, small town. Yeah. CNN this morning, they were interviewing the chief of police, and he was saying everybody in town knows affected by this, knows. I don't want to bother to watch the news. It's all bad. You're smarter than I am. You know, in the real world, you know, I'm here, the birds are singing, the tide goes out, it comes in, the trees color, and what happens in Washington, what they do, the trickle down, in terms of taxation, et cetera, and a lot of this other stuff. What does it have? I think the most recent clown show in Congress, for me, in the morning, instead of watching CNN,
No, I'm not.
Mike Greenberg on ESPN.
How good. You, what time? Okay, we'll get it. Can you give me about 5 minutes? Okay. Okay, thank you, bye.
I was glad to see the Astros did not make it. Yeah, but as far as Texas and Arizona, I don't know. I think so. Arizona made it with Randy Johnson. Yeah. I got the tech star that I really felt a lot for. Josh, last name in the drug in and up. Yeah, they've never. Yeah. I think fully retired or dead. He's got to be. He's got to be. He was out of drug issues. That's yeah. That's what a tragedy. Game 1 tomorrow night. I think tomorrow. Game 2 on Saturday on the radio on the way down. They said a kid from Washington will be singing the national anthem for Game 2 on Saturday. He won some competition. He's from Sumner. Sure, what's going on in the jail? We have somebody here. Aberco disappeared. Yes. Then I don't use this which is a little more problematic. You call there to talk to an inmate.
Welcome to Zoom. Enter your meeting ID followed by pound. You have not entered any number. Please re-enter your meeting ID. Enter your participant ID followed by pound. Please enter the meeting password followed by pound.
You were on an SOC that ended, and the only problem was well, you're here, so let's deal with it. You remember the SOC? One of the obligations was to pay $250. Come on up and have a seat by the that microphone there. Case was going to be dismissed if you stayed on it and paid $250. What do you want to do?
I'm currently not working. I actually stay in my car. I'm homeless at the moment. So I don't really have a way to pay. I mean, I can try and make $5 payments here and there, but that's about the best I can do.
So far, nothing has been, and again, this is an SOC, a contract between you and the city. I really don't have anything to say about it. Sometimes the prosecutor will say, hey, let's convert it to a conviction and just close the case. Forget about the fine. But I'm going to leave that. I'm going to defer to the city on that. You're an obvious violation of it. What I'm inclined to do is enter a finding of guilty with regard to the charge and then simply close the case. I'm not going to suspend any jail time or impose any fine.
Okay.
Is that going to work?
I didn't want to know my record, but you know what? It's okay.
That's-
You know, I can't make any payments right now, so it is what it is.
Let's do it that way. Hopefully, relatively minor matter. Let's enter a finding of guilty based upon the police report in the file,
Okay.
and we'll close the case.
Okay.
That concludes the matter. I'm going to wish you the best of luck. How has life been going otherwise?
It's
It
been
doesn't
going all
sound
right.
like it sounds a little on the rough side.
Yeah, but you know,
You
it'll
gonna
get
be
better.
able to
Huh?
Gonna be able to get into housing?
Yeah, hopefully. I'm hoping. I'm just waiting to hear back. So hopefully.
I want to wish you the best of luck with that. Be patient. Yeah, this is a wrong time of the year to be living in a car.
Oh, yeah.
Temperature is not.
Yeah, and
conducive.
especially my ex-boyfriend, he just smashed both my car door windows out. So
Oh, boy.
yeah, it's been pleasant, but I'm making the best do what I can. So
That's really all any of us can do.
Yeah.
That's really all we can do. I'm going to wish you the best of luck. You take care of yourself. The case is closed. I'm going to wish you the best of luck.
all right,
with,
thank you.
Finding housing. Thank you, ma'am.
Hi, Judge. Now I'm listening to this echo. They've got some.
Well, I think you.
I can kind of hear you through the computer a little bit. I wonder if we should just hang up. Let's see if we can hear you, Judge.
Okay, how's this?
We can. It's not great, but we can. Yeah.
Okay, I'll try to speak up a little bit. Does that,
Yeah, it's not too bad. I can hear you.
hey, and who are we,
So this is, William Dorsey. He's got item numbers 1, 2, and 3 on the 8:30 in custody calendar. And I've had an opportunity to discuss all of these matters with Mr. Dorsey. 2 of them are on for arraignment. I've discussed with him, what an arraignment is, to be read the charges in open court, the elements that the city would have to prove, the maximums that could be imposed, and a reading of his rights, right to trial, and all of that, to enter a not guilty plea. He would prefer to waive arraignment on those. And as part of a global resolution, I have prepared a statement of defendant on plea of guilty for him, with which I've reviewed with him. And we're proposing to resolve everything today.
I have the plea in front of me. It looks like the plea will be to 2 counts of criminal trespass, second degree, with the dismissal of the other counts.
Correct.
Mr. Darcy, good morning. I'm looking at a statement of defendant on plea of guilty to 2 counts of criminal trespass, second degree. Plea form tells me you're 50 years of age. Have you had any trouble going over the plea form with your attorney?
No, sir.
If you had any questions about what it meant to plead guilty, were your questions answered?
Yes, sir.
Now, the maximum penalty for a criminal trespass second degree is 90 days in jail and or $1,000 by way of fine. I would be free to impose that regardless of what's recommended. You realize that?
Yes, sir.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. With that in mind, as to 1 count of criminal trespass alleged to have occurred within the city of Yelm on September 12th, a second count alleged to have occurred on October 16th, both 2023. How do you plead, guilty or not guilty?
Guilty.
Do you make those pleas of your own free will?
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty except the recommendation of sentence?
No, sir.
I will find the plea to be pleased to be freely, knowingly, and voluntarily made, and your statements in paragraph 11 to satisfy the factual elements of the charge. The recommendation is all suspended jail time, no fine. Is that correct, Mr. Haverco?
It is, Judge. Yeah, the recommendation was credit for any time served, the balance suspended for 12 months on the condition of law-abiding behavior because of Mr. Dorsey's indigent status. The city was not requesting a fine.
Mr. Redfield, anything to add? Mr. Dorsey, is there anything you'd like to tell me? Now's the time. If you don't have to say anything, but now's the time if you do.
I'm very sorry.
I'm going to follow the recommendation, 90 days in jail, all suspended on each charge. Conditions of the suspension are law-abiding behavior, and that would include controlled substances. Now, we're dismissing those charges, but I'd like you to save your life. That's too many people are dying of the consumption of drugs. I want you to keep that in mind, and I want you to make better judgments in the future. Any questions at all?
No, sir.
I'll sign a judgment and sentence to the effect you'll be getting a copy of it, and your attorney will too. I'm going to wish you the best of luck, Mr. Darcy. You take care of yourself.
Okay, you too, sir. Thank you very much.
Hey, thank you and good luck. Unless there's some other hold on you, you'll be released today.
Okay, thank you.
Thank you, Your Honor. So go ahead and. You bet. Come on, Sam. How you doing? All right.
Ready to proceed.
Oh, thank you, Judge. So this is Robert Anthony Trevino. He is on item numbers 4 and 5 on the 8:30 in custody calendar. 2 matters. One is ending in 949. That's item number 4. That's on for an arraignment. And the other matter ending in 946. That's on for a pretrial hearing. That was previously scheduled at the next court date, but because he's in custody, the clerk was able to get it moved to today. He understands, with regard to the case that's on for arraignment, he understands what his rights are pursuant to an arraignment, to be read the charges in open court, the elements that need to be proved, the maximums that could be imposed, and his constitutional rights. He would like to waive formal arraignment and proceed by way of a plea with a plea agreement that's been reached with the city. And I think that's reflected in the statement of defendant on plea of guilty, Your Honor, of which I've reviewed with Mr. Trevino.
Morning, sir. Is your full name Robert Anthony Trevino?
Yes, sir.
Do you disagree at all with anything Mr. Haverco just said?
No.
You're willing to skip arraignment on the one case and proceed to an agreed disposition. Is that correct?
Yes, sir.
I'm looking at a statement of defendant on plea of guilty to one count of criminal trespass, second degree, and one count of knowing possession of a controlled substance. Have you gone over the plea form with your attorney?
Yes.
Plea form tells me you're 20 years of age. If you had any questions about what it meant to plead, was your question answered?
Yes.
If I accept the plea, you're liable to up to 90 days in jail and or $1,000 fine on the criminal trespass charge. And on the knowing possession charge, the maximum for that would be 180 days and a $1,000 fine. I'd be free to impose that regardless of what's recommended. You realize that?
Yes.
I accept the plea. You give up the rights contained in paragraph 5 of the plea form. No trial, no appeal, simply a sentencing. You realize that?
Yes.
As to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on October 16th, and one count of a controlled substance occurring on October 7th. How do you plead, guilty or not guilty?
Guilty.
Do you make those pleas of your own free will?
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
And the pleas to be freely, knowingly, and voluntarily made, and your statements in paragraph 11 do satisfy the factual elements. The recommended sentence is all jail time suspended on the condition you have law-abiding behavior, and that would include the consumption of controlled substances. Mr. Haverco, anything to add?
Nothing to add, Your Honor.
Mr. Hatfield, anything to add? Mr. Trevino, anything you'd like to say?
I'm sorry.
I'm going to follow the recommendation. 90 days in jail on the criminal trespass, 180 days in jail on the knowing possession, all suspended on the condition you have law-abiding behavior. They don't see any recommendation as to treatment, but that is always an option. And I'd like to see you, you're 20 years of age, you've got a lot of time in front of you, if you can leave the controlled substances alone.
Yes.
I'd like to see you make better choices, but that's your choice, not mine. Okay? Any questions at all?
No, thank you. Thank you, Judge.
Mr. Davino, that's whether I see you again or not is entirely up to you. That's I'm hoping you make better choices in life. Okay.
I will. Thank you, Judge.
Unless there's other holds on you, you'll be released sometime later today. Okay.
Okay. Thank you.
Good luck to you.
Thank
Yep.
you. Thank you, Your Honor.
That's it. Please, go to the 9 o'clock calendar. First call, Stephen Bacon. Mr. Bacon, come on up and have a seat with your attorney. Matter set for a pretrial today. Mr. Coker, I'll defer to you for the status of the matter. Did you have anything to add, Mr. Rathfield? Mr. Bacon, I'm looking at a stipulated order of continuance on the screen here in front of me. Well, one of the good news is that you're here and you're healthy and it looks like you're on the road to maybe a better style of life. The other good news is that your attorney has negotiated a resolution of the case. It doesn't involve a conviction for a DUI. I've said many times that, in my opinion, a DUI conviction is worse in terms of impact on your life than a lot of felony convictions. But your attorney's just put you in a position of being able to get this matter resolved to a negligent driving in the first degree, which is a much less serious charge. Whether that happens or not is up to you. The conditions are principally stay out of trouble. Do not reoffend. Now, in return for the agreement, you've given up your right to go to trial. If there's a violation and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports, and that would have a very bad result, more likely than not. I approve of the agreement. I'm going to wish you the best of luck. You've got a chance to walk away from this with a good resolution and a much better way of life. Mr. Coker, anything to add at all?
Just,
Oh, certainly, certainly. Mr. Bacon, a good idea would be to check with Mr. Coker towards the end of the year to make sure everything's okay. Is there any monetary? The monetary part of it, that's the least important. The most important part of it to me is that you have learned from the experience and the experience will not be repeated. Mr. Bacon, good luck to you. That concludes the matter. Take care of the financial part of it and have a good life.
thank you, Your Honor.
Thank you, Your Honor.
And yeah, it's always good to see somebody that sees a problem and I'm going to do what I need to do to rectify it, to get past it. Good luck to you. I mean that.
I'll send treatment as well as.
Perfect. Thank you, Mr. Coker. Take care. Have a good day.
You too.
Hey, Donnie, I must have hit the wrong button. Yes. So could you get a copy of the agreement? Read it over carefully, and if you have any questions at all, give Mr. Coker a call. Good luck to you. Hey, Donnie, I think let's what did I do here to there. It was all. But now it's okay now. It's okay. Next call, the matter of Yelm versus Marcel Harris. Mr. Harris, come on up and have a seat. I understand your attorney is present. Yes. Mr. Girl, good morning. Are you able to hear me?
I can hear you. Can you hear me, Your Honor?
That I can. Call the matter of Yelm versus Marcel Harris. Turn to the parties for the status of the matter. Mr. Girl. Go ahead.
Your Honor, I believe we have reached a resolution and the city has the documentation.
I'm looking at a stipulated order of continuance in the O Court system. Mr. Girl, I'll defer to you.
Your Honor, we have reached a resolution in the form of a stipulated order of continuance that over a period of 12 months, the current charge of domestic violence, no contact order violation, upon successful compliance by Mr. Harris, that charge would be dismissed with prejudice, I believe with no need to reappear, although I'll defer to the court on that. I did go over this paperwork with Mr. Harris in full detail yesterday. He had a chance to review it. We spoke over the phone about it. I advised him of the rights that he's giving up by entering into this. I also advised him that this is essentially a contract between him and the city. If he abides by all the conditions that he's agreeing to comply with, the city is bound to move to dismiss the charge at the end of 12 months. On the other hand, if he fails to comply with any of the conditions that are delineated within the agreement, the city could bring a motion to revoke the agreement. I could certainly argue on Mr. Harris's behalf against the revocation. But if the court were to revoke the agreement, I would have no opportunity from that point forward to argue against the evidence in the case. So in other words, he understands he's given up the right to a trial in this case, and he's also given up the right to contest the evidence. And I have advised him that in all likelihood, the court would make a finding of guilty by reading the police report that he understands and stipulates can be filed with this document today. Your Honor, I believe this is a fair and equitable outcome in this case. I believe that Mr. Harris is making a knowing, intelligent, and voluntary decision by entering into it, and I would ask the court to allow the parties to move forward with this as a way to resolve this matter.
Is your full name Marcel Dwayne Harris? Yes. Mr. Harris, do you disagree at all with anything that your attorney just said? No. I'm looking at a stipulated order of continuance in the O court system here on the screen. This is an agreement under the terms of which these charges can be dismissed if you stay out of trouble and have no hostile contact with the alleged the victim in the matter. Now, in return for the agreement, you've given up your right to go to trial, have witnesses, et cetera, et cetera. That's if there's a violation and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports and argument of counsel, and that would most certainly result in, almost certainly result in a bad result, which would subject you to up to 364 days in jail on each count. I might advise you at this time that the facts of the case were extremely concerning to me, and if there was a violation and did result in a conviction, I would be imposing more likely than not some pretty substantial jail time in the matter. I'm hoping you've learned from this. I'm hoping that this is a situation that's not going to be repeated. I will approve the agreement that has been reached by the parties that know more about the case than I do. And all I can do is wish you the best of luck and hope that the situation resolves. Yes, a pretrial no contact order is as a condition is amended to no hostile contact. Now, that is a rather vague way of putting things, and what that means is any contact between you and the alleged victim that's at all unpleasant or unwanted by the victim, I would consider that to be hostile contact. We don't want to go there. Concerned about the individual involved, and I hope his life is going well. That's all I can say at this time. I wish you the best of luck. And if we don't resolve the problems that we have, and if we don't learn from our mistakes, we're going to repeat them. There's no question about that at all. Mr. Girl, anything to add?
No, Your Honor. Thank you. And thank you, counsel.
Mr. Radfield, anything to add? Mr. Harris, I'm signing the order. You'll be given a copy of that. I want you to read that over carefully. And if you have any questions at all about what it means, certainly give Mr. Girl a call. Okay? You take care of yourself. Bye.
Thank you, Your Honor. Your Honor, I'm also here appearing on behalf of the Attorney of Record, Seth Taninga, on the Alexander Davis matter.
I'm wending my weary way through the O court system. And when I can find my way back to the dashboard, I am there, and I note, and I have in front of me a motion to continue the matter to December 7th.
That's correct, Your Honor. My understanding is that the parties are still working on negotiations in this case. Mr. Taninga just needs a little more time to fulfill his investigative duties on behalf of his client. I'm assuming that there's no objection by the city. I'm not aware of any, but I'll defer to counsel on that.
No objection. Hearing no objection, I'm going to approve the resolution of set over. I'll be sending Mr. Taninga a copy of the order as well as his client. So that concludes that matter as well.
Thank you very much, Your Honor. Thank you, counsel. Have a good day. Bye-bye.
Next call the matter of Yelm versus Caden Barton. You're not ready on that? Fine. Come back to that. Let us know when you're ready, and we'll call the matter. Both. Good morning. Call the matter of Yelm versus Eric Markowski. Mr. Trudeau, good morning. I understand your client is on Zoom as well.
That's correct, Your Honor, and we are ready to proceed. I believe the city has a motion today.
So do you have a motion in the Markowski case?
Yes, Your Honor.
Docket number 6.
City's moving to dismiss.
I'm looking at an order of dismissal, and I don't believe there's probably going to be any objection to the entry of the order of dismissal.
No, Your Honor.
And the dismissal is without prejudice. Mr. Markowski, what that means is if the city reconsiders or further information arises, they change their mind, they can refile the case. It's been my experience that once a case is dismissed, it hardly ever resurrects itself. This case is dismissed. We'll be sending your attorney and you a copy of the dismissal order. If you have any questions at all, now's the time to ask them.
No, sir. Thank you, Your Honor.
Markowski, I'm going to wish you the best of luck. You take care of yourself and have a good life.
Thank you.
Take care.
Thank you, Your Honor, and thank you, Mr. Prosecutor. That's all I have today.
Mr. Joe, thank you. You take care. Have a good day.
You as well.
Yeah, let's call it. Good morning, Mr. Catterhorn. Can you hear me?
Yes, good morning, Your Honor. Well, looks like Mr. Trudeau beat me on the Markowski matter, so I'm only here on the Bennett matter, Your Honor.
We'll call that matter now. That's set for a pretrial. Turn to you for the status.
Thank you, Your Honor. Attorney Chris Cattenhorn appearing in accordance with 3.4 today. I've had regular communication with my client who's given me authorization to act on his behalf. This is a defense motion to continue for further investigation and negotiation. We are potentially exploring a deferred prosecution in this matter. I am happy to report that Mr. Bennett has fully engaged in the treatment for that portion and is in full compliance. So we are taking some proactive steps and he is doing quite well.
Hey, the proposed order is to December 21st. Is that agreeable?
That would be that I selected that date based upon my calendar, and I'm hoping the city has no problem with that.
Hearing no objection from the city.
No objection.
We'll reset the matter to December 21st, and we'll be sending your client and you a copy of today's order.
Great. Thank you very much. Have a good day.
Catterhorn, take care of yourself, and you have a good day as well. For Mr. Stock. Okay, sure. Let's. Good morning, Mr. Lewis. We'll call the matter of Yelm versus Austin Rogers at this time. Matter set for a pretrial. I'll defer to you for the status of the case.
Thank you, Your Honor. Thank you for calling the case. I'm appearing on behalf of my associate, Mr. Matt Stock. This is going to be a 3.4 appearance on behalf of Mr. Rogers. We're just asking that this matter be continued in due course. There's a waiver and a motion uploaded into O Court.
I'm looking at the motion and the order resetting to December 7th. Is that an agreed date?
It's good for the defense.
No objection.
No objection from the city. I'm signing the order, resetting the matter to December 7th. I'll be sending Mr. Stock a copy of the order as well as Mr. Rogers. Okay.
Very good, Your Honor. Thank you so much. May I be excused?
Mr. Lewis, take care and have a good day.
You too. Thank you.
Mr. Ross, good morning. The prosecutor stepped out of the room, but
Good morning, Judge Myers. Always good to see you.
and good to see you as well. Having a little trouble navigating through.
Yeah, I wrote a fairly detailed motion to continue in O courts. I'm not at the point of seeking any other form of, trying to figure it out because Ms. Squally is doing her best. But yeah, it's kind of confusing.
That's Ms. Squally is present in the courtroom. Good morning, ma'am.
Yeah, she is. She's present in person.
That the matter be set over to January 4th. Of that matter, is that that's going to work out for you?
Yes, Your Honor.
Your Honor, just to be clear, are we on the record? I wasn't sure.
We're on the record.
Okay, Your Honor, the reason why I put January 4th was because, good morning, counsel. Jossie Ross on behalf of Ms. Squally, who was present in court for the record. Your Honor, I uploaded a proposed motion to continue for Ms. Squally in this matter. And just for the record, Ms. Squally has diligently been seeking who she is to pay. That's not something you hear every single day. She initially went to the landowner. Apparently that's already been addressed by the insurance company. So she's been in contact with the insurance company with no success of them contacting her back. So that's the dilemma, is that she's trying to pay money that is the subject of this compromise of misdemeanors. And unfortunately, there hasn't been the welcoming arms to receive that money, and so, Your Honor, I put January 4th as a default because the O courts did not go out further than that. I actually proposed around 6 months for Ms. Squally to find the proper recipient. I believe that was around April 18th. I think that was a Thursday. But I wasn't able to do that because it was not populated by O courts on the calendar.
So, well, O Courts tells us we can't set it out that far. That's the one
Okay.
that I resent about the system. Is it pretty much tells you what to do instead of vice versa. The furthest we can go is to January 4th, which we will.
Okay.
I want to assure you and Ms. Squally that I realize that I've had a couple of times during my experience and career as a lawyer that I'll have money in the trust account and it's either owed to this person or that person, and I can't get anybody to take it. I had to sit on $15,000 for about 2.5 years before I could get an heir to take it. These things do take time. Excuse me. We're going to reset it out to January 4th, which is as far as we can go. Stay in touch with Ms. Rossi, and we'll deal with the matter in January. Okay.
Thank you.
Thank you, Judge. Thank you, Judge. Thank you, counsel.
The hearing, we'll be sending Ms. Squally and yourself Mr. Rossi, good to see you. You take care of yourself.
Thank you.
Next call, the matter of Yelm versus Melissa Ulrich. Is Miss Ulrich in the courtroom? Ms. Ulrich, come on up and have a seat at the council table here. Mr. Valley, good morning.
Good morning, Your Honor.
Well,
I'm having a heck of a time with O Court. I still don't have discovery. I asked for it like I said I would last time, and the response I got was that it would come from the court. So I'm in a loop. I'm computer literate. I can't open an account at O Court, and I'm not getting paid for this. This is, I think, the 4th time we've been here, and I don't have a police report. And I've done everything I can. Right now, what I try to do, it asks me for my JIS credentials and my JIS password. I don't have, I'm not a JIS. I'm a private individual. I'm not JIS. The problem is on O Court's end, unless it results only from the fact that I'm trying to do this on a phone and not a personal computer. And I've been trying to do this for 2 days. I didn't wait until this morning. So I need to ask for another continuance, Your Honor.
No problem with that. Let's figure out how to get the police reports to you. You don't have a computer and don't have.
Got to be a better way. Yeah, I don't mean to interrupt the court, Your Honor. I apologize.
Do you have a fax machine?
Well, it seems to me someone should be able to email me PDFs without me having to jump through. I don't mind jumping through, and here's another problem in our world, and it is a problem, and I say this as an officer of the court. Every different court has a different system you need to belong to. And an inherent problem in that means all of our information is in a whole bunch of different places with passwords and accounts and access and vulnerabilities. And so it seems to me someone should be able to send me a PDF, or I'll drive to Yelm and pick up discovery. I have not had a fax machine for well over a decade, and neither has anybody else I know.
Well, I have one.
I know, and I'm not trying to be petulant or more petulant than I need to be, or certainly not counterproductively petulant.
Oh no, Eric, that's clerk tells me that we did send you the back in July. For some reason, that isn't getting through.
Well, that mail would work, and although I believe that I did not receive anything hard copy by mail, of course I do check my mail. That might have been an old email address. If I could update my email address, because I no longer use one I used to use, and now I use esvalley@gmail.com.
That's the one it was sent to.
Okay, and I'm happy to look, but we shouldn't take up the court's time while I do that. A brief, please, Your Honor.
Let's reset it out to November 9th or 21st.
Let's go the 9th. Let's just get there, Your Honor. I may be busy then because I've got I think I have a big trial starting in December, but early December, not early November. And credit where credit's due. I have spoken, and now I even have some more cases with the prosecutor. So we are in negotiations and discussions, because as we've told the court, this happened on the day of a disastrous event. My client lost a family member. So we're trying to seek a resolution short of, and also I think the blow was high. So, and my client is clean and sober and not out. Yeah, I think she's not in treatment, but everything is okay, including the fact that we are in discussions.
We'll reset it. Since you don't have access to the O courts, I'll ask Mr. Ratfield to generate the necessary order to reset it.
And I said in Thurston County Superior Civil Court, Mr. Ratfield and I are getting along famously. So that should work great.
Politeness and cooperation between council is no longer as common as it used to be. I'm glad to hear of it when it does happen. Mr. Valley will send you a copy of the order resetting the matter, and you take care of yourself, and good luck to your client.
Can't thank the court enough, and I'm glad to see my client there too. Thank you, Your Honor. I'll take my leave.
Take care. So Rick, I'm looking at an order that's being prepared as we speak, resetting the matter. As soon as that's prepared, I'll electronically sign it, and you can get a copy of that at the window.
Thank you.
Stay in touch with Mr. Valley, and and we'll get the case moving. But it sounds like things are going very well for you right now, anyway. And that's really the important thing.
Am I free to go?
November 9th, 2023. Yes, it now looks like it's ready for me. I'm signing it electronically. You are. The copy of it you can get at the window just outside the courtroom and to your left.
All right. Thank you so much.
That should be prepared. Ma'am, thank you. You take care of yourself.
Thank you.
Well, except for Mr. Young, come on up and have a seat. We'll address your matter at this time. That's it. And thank you for your patience. Good morning. I'm looking at
Yes,
the
Your Honor. City moves to amend the charge.
motion granted.
Yes, Your Honor.
Young, do you disagree with anything your attorney just said? Your full name is Reason, middle initial W, Young.
Yes, sir.
Mr. Young, I'm looking at a statement of defendant on plea of guilty to one count of reckless driving. That is what they call a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. I would be free to impose that regardless of what's recommended. We'll get to that in a bit. The plea form tells me you're 28 years of age, you have a GED. Any problem at all understanding the plea form?
No, Your Honor.
Gone over it with your attorney?
It's clear, I have, yes.
You've given up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. And that will result, if I accept the plea, in a suspension of your license. The Department of Licensing does that. I don't, and that'll be probably for a period of 30 days, but I'll leave it up to them. With that in mind, as to one count of reckless driving alleged to have occurred within the city of Yelm on June 2nd of 2023. How do you plead guilty or not guilty?
Yes, guilty, Your Honor.
Do you make that plea of your own free will?
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
Find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. The recommended sentence is 364 days, 362 suspended. A fine in the amount of, it looks like $250, $250, and a 2-year jurisdiction. City, have anything to add?
Nothing to add, Your Honor.
Anything to add on behalf of Mr. Young?
Your Honor, briefly,
perspective.
treatment, doing a 6-month program through rating. IFO.
Yes, yeah.
Complete that. And that's about the most important part, I think.
He's also completed the victim impact panel.
Certainly. Mr. Young, anything you'd like to tell me? You don't have to say anything, but if you want me to know anything, now's the time.
I don't believe so. I just know that, I did mess up and I'm trying to do everything that I can to, make things right again.
Yeah,
So,
and you're right. It's not how many times we fall down. It's getting back up that counts. And it looks like you've learned a lot from the experience, and there's a lot harder way to learn it. Any lawyer in the room could tell you about countless cases where people didn't make it. The phone call had to be made to family. The so-and-so died, is in the hospital, whatever. But you're here and you've looked at the situation, looked at your life, and you've made a really good choice to say, hey, I got to move on from this. You're doing that in a good sense. I'm going to follow the recommendation. 364 days in jail, 362 suspended, credit for 2 days served, $250 fine. And I think the most important part to me is the drug and alcohol follow up on the treatment there.
absolutely.
And law-abiding behavior, of course.
Mhm. Yeah, thank you, Your Honor.
I'm going to wish you the best of luck. It's always really good to see somebody, and you don't see it very often, that walks in that's been proactive as you have been. I want to tip my hat to you for that. And I'm going to wish you the best of luck. Move on with life in a much better fashion. Your
Thank you.
attorneys negotiated a very good resolution of the matter. You may have heard me say a while ago that a conviction for DUI in terms of impact on your life is worse than a lot of felony convictions. So you're off on the right foot. So you take care of yourself. Have a good life.
Thank you.
Counsel, thank you much. Take care. Any questions?
No, sir.
I will, I have signed I'll be signing the JNS after I review it briefly. You can get a copy of that at the window outside the courtroom to your left before you leave. Mr. Young, go ahead and review it carefully. And if you have any questions, give your attorney a call. Good luck to you. Thank you. Back on record, Mr. Haverko, any matters to put
yeah.
on the record at this time?
We do, and this is Mr. Busby on the,
Mr. Busby, good morning. How are you?
it's on the 10 o'clock calendar. And, so go ahead and say your name on this. So, Mr. Busby comes on this morning on, one case that's set, actually two cases that are set for a pretrial hearing, but then there's a new case that's on for arraignment. So I have prepared a motion to continue on his two, that's fine. So I prepared a motion to continue on the two pretrial cases, on the anticipation that I'll be appointed on the arraignment matter, and then we can just reset everything together, and I'll have, the report and all the materials needed to discuss everything for hopefully some kind of resolution.
Let's do the resolution, or let's do the arraignment first, and then we'll just consolidate everything. Sure. Morning, sir. Is your full name David Arthur Busby? Mr. Busby, citation was issued on October 14th, 2023, alleging that on that date you committed the offense of assault in the 4th degree, gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and a $5,000 fine. It's you're also cited on September. So that is the new case. I'm going to appoint Mr. Haverko to represent you on your new case as well as the other cases, and he'll enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate probable cause, ask the court to enter not guilty plea on that new matter.
Mr. Busby, a plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial consolidated with your other cases. Conditions of release are stay out of trouble, no law violations, no further disruptions of Mr. Johnson. Stay away from that. You also have the criminal trespass case dating to September 21st and a criminal trespass case of the same date. Mr. Busby, a condition of release is always law-abiding behavior. That was the condition in the other case. I'm not going to have you taken into custody and set bail on you, but you need to stay out of trouble.
Okay, sir.
Busby, likewise signing an order resetting your other cases to December 7th as well. I want you to get a copies of today's orders. Do that at the window outside the courtroom to your left. Stay in touch with Mr. Haverko, and once again, law-abiding behavior, okay? Yeah. Take care of yourself.
Would Your Honor mind taking up a 1 o'clock matter?
Absolutely not. Sir, come on up and have a seat.
This is Michael Akins, Your Honor. He's item number 1 on the 1 o'clock calendar.
Good morning, sir. Full name Michael Shane Akins. Mr. Akins, you remember talking to me yesterday? I'm the guy that called the jail.
Yes.
That was This was regard to a citation for theft in the third degree. Filed dated October 23rd, 2023. That's a theft third degree is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You have a right to have a lawyer, and I'm going to appoint Mr. Haverko to enter a plea on your behalf at this time and represent you throughout the course of this matter.
Stipulate probable cause, Your Honor, ask the court to enter a not guilty plea.
Mr. Akins, a plea of not guilty has been entered on your behalf. That preserves your rights pending a pretrial.
He won't take the plea.
Mr. Akins, what I want you to do is get a copy of today's order at the window, and I want you to exchange contact information with Mr. Haverko, your attorney, and stay in touch with him.
Phone number? Oh, that's okay. So we'll just talk at the court date. Yeah, that's good. That's okay. That's okay. No, it's okay. No. Or, so I could not be deemed to have you do that.
Mr. Akins, I'm signing the order resetting the matter to December 7th. I want you to get a copy of that at the window outside the courtroom to your left, and we'll see you back here in December, okay? In the meantime, conditions of release are law-abiding behavior, and any place from which you've been trespassed or not to go back, and that would include the restaurant where this happened. Any questions at all? That falls on a Thursday.
Yeah, it's free. Yeah, go to the window, before you go and they'll give you your paperwork. Yeah. I don't think I have any other matters other than to speak with Mr. Butler, who's here.
Okay.
Mr. Butler.
Mr. Back on record, going to call the matter of Yelm versus Caden Barton. Good morning, Mr. Barton, full name Caden Andrew Barton. Turn to Mr. Schuman for the status of the matter.
Good morning, Your Honor. Stephen Keeler with Mr. Barton. Your Honor, we have reached document stipulated order of continuance. Mr. Barton and I have reviewed that. Emphasized he understands that by entering into that agreement, it's basically a contract with the prosecution, and then in entering into that, he's waiving all of his constitutional rights, trial, witnesses, confront witnesses, appeal determination of guilt after trial. He understands he's waiving all that, and he understands that the speedy trial commencement date will be October 26th, 2024. We anticipate that that's not going to be necessary. The fact of the matter is, he understands 12-month continuance, and the conditions he needs to abide by. Specifically, no criminal, no refusal requested by law enforcement, no alcohol infraction. He has already obtained a drug and alcohol evaluation filing after court. He has been done the NSP, so he's been doing ADIS and breath test, of which there was some excuses part of what he's going to be doing 3 monthly UAs and meetings after doing ADIS and DIS. So I have that. So he's been really close. He's mitigated the investigability, but he also understands that he understands that's a simple misdemeanor, and he understands that the recommendation can be no jail time. He also understands that if he doesn't follow through, or if he somehow gets in trouble, it's not going to happen, because this is the first of any contact with the criminal law justice system. But if he got in any more trouble, that there isn't going to be a trial. Your Honor is just going to reasonably support and make a determination of guilty based on that alone, that we will not be able to have any objections or motions or anything like that. I've told him that if Your Honor reads just the report, well, the outcome is pretty well spelled out. This is a great one. I think he's doing it knowingly voluntarily.
Mr. Barton, do you disagree at all with anything Mr. Schuman just said? He has negotiated on your behalf a contract under the terms of which this case can be resolved by a reduction to a much less serious charge 12 months down the road. He's put you in that position, but it's now up to you as to whether or not you follow through with that. It sounds like you're doing well. It sounds like you've been very proactive in terms of dealing with this. First experience with the law enforcement community. It's not a good one, but you're getting a very good resolution of the matter. I've said many times, and I'll say it again, a conviction for DUI is much worse in terms of impact on your life than a lot of felony convictions, which are supposedly a lot more serious. The conditions, the most important one to me is you've learned from this. This is not going to happen again. I don't need to tell you about the number of people we kill every year on the road. All you have to do is pick up the newspaper, or do what I'm trying to avoid doing, is turn on the news. I approve of the agreement. I'm going to wish you the best of luck, and it's rare, but it's good to see somebody who's been really proactive in dealing with the situation in life. I'm going to wish you the best of luck, and I think Mr. Schuman is right that we won't be seeing you again. No. Yes, sometimes on these things, courts want you to come back in and for a formal dismissal. I'm going to waive it as long as everything's okay. Stay in touch with Mr. Schuman. Maybe make sure close to a year from now that everything is okay. And we'll cheerfully dismiss the case. I'm signing it as we speak.
And does the court's calendar instead of?
We don't usually bother to calendar it. It's just tickled and then dealt with down there. That was
I like
calendared it. Okay, we calendared it for the, yeah, that's, it doesn't have much of a sense of humor, so there's no point in that. That was, if you want, if you can take this to the front window and for filing and get, and have a copy made for yourself and your client. And, yep. That concludes the matter. Mr. Barton, I'm going to wish you the best of luck. You take care of yourself. Have a good life. Likewise, and also. Everyone that is here for a pretrial, and Mr. Haverco is your attorney. He'll call the cases in the order in which they're ready to go.
You could, Your Honor, I think it's a matter of the 10 o'clock calendar that of Andrew Duke. See, parties have reached agreement. I believe the city can move.
So on the 10 o'clock calendar?
Yes. Andrew Duke. Number 14.
Andrew Scott Duke. So Duke, good morning. Not finding anything yet in Oak Courts.
Because it's an amendment to an infraction, negligent driving second degree. Yeah.
Mr. Duke, a gross misdemeanor, not a gross misdemeanor, which there's a significant amount of jail time, has been amended by the city to one count of negligent driving in the second degree of civil infraction. If you admit the infraction, I'll impose a fine. You admit that you drove in a negligent manner on September 21st. Recommended fine? $250.
Sure.
I'll impose a $250 fine, which you can pay at the rate of $50 a month. Is that going to work? Is this one of those racing speeding cases?
Yep. No record, Your Honor.
Mr. Duke, the good news is you're getting a pretty serious criminal charge, which bears license suspension, horrible insurance premiums. You're getting that reduced to a simple, infraction. That'll go on your record as such. It will have an impact on your insurance rates, but the good news is you're here. That's the young man that lived right next door to me a number of years ago. He used to use my driveway to run his motorcycle up and down. He got involved in one of those racing situations. He and two friends, I knew one of them, they missed a curve on East Bay Road going out north of Olympia. Went head to head with a tree. Hopefully they all died instantly rather than burned to death, which is a horrible death. The car caught fire. But that's the result of the racing behavior that sometimes happens. You don't want to do that. Driving a car is probably the worst thing the most dangerous thing you'll ever do in your life. Slow down, take it easy, keeps the insurance premiums down, and it saves lives. Good luck to you. I'll sign the order. I'm doing that at this point. I want you to get a copy of that at the window out in front and slow down and get there. We could all live at a slower pace in life and not involve ourselves in any automotive muscle flexing. Any questions at all? No, it's up to you to pay $50. We're setting it at $25 a month. The,
Mail in a check, stop by the window, you can do it like.
by mail, by check, no reminders. The reminders would be a warrant, for your arrest if it was a criminal matter, but in your case, it would go to the Department of Licensing as a failure to appear. You'd get a notice your license is suspended. We don't want to go there. Yes, it's possible.
Yeah,
25 is just the minimum payment. If you could pay the 250 and forget about it, I would advise you to do that. So, but that's your choice. I'm going to wish you the best of luck. You take care and drive carefully, drive safely. Mr. Duke, you as well. Take care. Mr. Butler, good morning again. For the record, your name is Josh Nathan Butler.
Well, I guess we'll have to reload the form in Oak Courts because it's not letting me set up the signature thing for Mr. Butler. Let me just see if I can pull it up again. It'll work this time. There we go. Josh, go ahead and sign. So this is Joshua Nathan Butler. Matter comes on for a couple of pretrial matters. Parties have reached an agreement, that being he's going to enter straight pleas to the 2 criminal trespasses, but with those being amended to criminal trespass in the second degree. And then upon the court's acceptance of those pleas, the city will move to dismiss the theft charge. And because of his indigency, the city was not asking for a fine.
Mr. Butler, do you disagree with anything at all Mr. Havercoat just said?
I agree with everything you said.
Go ahead. I'm looking at a statement of defendant on plea of guilty to 2 counts of criminal trespass, second degree, including a dismissal of a theft third charge. Plea form tells me 31 years of age. Have you gone over the plea process with Mr. Havercoat? And if you had any questions at all, were your questions answered? I know we've been through this before, but we've got to do this. You're giving up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 90 days in jail and up to $1,000 fine, regardless of what's recommended. You realize that. With that in mind, as to 1 count of criminal trespass, second degree, and 1 count of second count of criminal trespass, second degree, on August 11th and again on August 29th, 2023. How do you plead guilty or not guilty?
Guilty, Your Honor.
Do you make those pleas of your own free will? Anybody make any threats or promises to you to make you plead guilty? I will find the pleas to be freely, knowingly, and voluntarily made, and your statements in paragraph 11 do satisfy the factual elements of the offense. Anything you'd like to tell me, Josh? That's Mr. Havercoat, anything further?
Nothing to add, Your Honor. Just in talking to Mr. Butler, I've known him and met with him many times over a period of time. And he does seem to be experiencing a little bit more distress and conflict at this point in time. And so I'm a bit concerned for him. And I mentioned to him, seeking out services of some kind might be really helpful. He seems to be having some real life struggles right now. We talked about that.
Josh, I share those concerns. It looks like for a while, you do well. You're doing well. You're upbeat. You're looking forward to life. You're having a good time. And then other times you go into kind of a tailspin. That's beyond, what I can do for you. All I can do is threaten you with jail time, which really doesn't accomplish anything. But I want you to take Mr. Havercoat's advice and seek some services, okay? That might, don't give up on yourself. okay? I'm not gonna give up on you. Don't give up on yourself. When you give up on yourself, that's the end. You've got a lot of life ahead of you if you want to enjoy it and live it, but it's up to you. But we all need help, and sometimes in our lives, we all have problems that we need help with resolving. And I want you to think, at least think about what I say, and maybe keep your chin up and maybe seek services. Some things that the problems we have that are unseen are sometimes worse than the broken arms and broken limbs that we can see. But yeah. I can see your suffering, and I don't like to see that, but I want you to do something about that. And that, I think, means services. 90 days, all suspended on each charge on the condition you have law-abiding behavior. Given your financial situation, I'm not imposing any fine at all, okay? Mr. Butler, I want you to get a copy of today's paperwork at the window outside the courtroom to your left. Look it over carefully, and then call Mr. Haverko if you have any questions. Good luck.
Oh, just go up to the window when you go out the door, take a left, and just go up to the window, and the clerk will help you. Yeah, go ahead. Go see the clerk. Yeah, right. Yeah, we're done. Yeah, you can get up, take a left, and go to the window. Yeah. Okay. Hey, Jeff.
And the theft charge is dismissed.
See ya. Next matter is going to be Chance Dixon. It's item numbers 12 and 13 on the 10 o'clock.
Mr. Dixon, come on up and have a seat.
Got a couple matters that come on today for pretrial hearing, and the parties have reached an agreement. Going to wrap both matters into the single stipulated order of continuance, conditions, no law violations for the 12 months, and global, the intention is a global probation fee of $250, which I guess it could be split $125 each, or
Your full name is Chance Dean Dixon. Is it? Mr. Dixon, I'm looking at this SOC, stipulated order of continuance, which basically is a contract between yourself and the city, negotiated by your attorney, under the terms of which you can get these charges dismissed if you comply with some conditions. The most important is learn from this. Don't commit any further criminal law violations. There's also a $250 cost involved. What I would like to do is review the file of 12 months from now and simply drop the cases based on your good behavior and full payment of the fine. Now, if you violate the agreement and the city proves that, we'll have a hearing based on the police reports. That's an almost automatic conviction. You don't want to go there. That involves up to 364 days in jail on one case and up to 90 on the other. Don't want to go there. You have a chance to get these cases dismissed, which look really good on your record, but whether you do that or not, it's up to you. Good luck, Mr. Dixon. What I want you to do is go to the window, get a copy of the agreement, look it over carefully, and if you have any questions, give Mr. Haverko a call. Any questions at all?
excuse my voice.
You certainly will. How about we set it at 25 a month? First payment due November 26th. That gonna work? Now, if that doesn't work, financial circumstances change, don't just ignore it. Let us know. We can deal with it. Give you continuances, go to communities or whatever. But yeah, November 26th. And that's gonna be in the order that you can get a copy of at the window, okay? That's all right. That's all right. I just hope you're feeling better. Are you on the road to recovery anyway? Good luck to you. Good luck to you.
Go ahead and sign. This is Mr. Lightcaster. He's item number, let's see, 15 and 16 on the 10 o'clock pretrial calendar. Matter comes on before the court for pretrial hearing on suspended second ignition interlock device violation. My understanding is he's making some substantial progress towards getting relicensed and working on that. So we're asking for what were we asking for, a couple months? 8 weeks, yeah. So we're asking for like an 8 week, approximately an 8 week continuance.
How about December 7th?
Sure.
Mr. Lancaster, that's for the record, your name is Regulus Lancaster. That's the most important thing to me is I'd like to see you get relicensed and drive out there legally. We live in a world where you've got to be able to drive. So we're going to reset the matter to December 7th. And hopefully you'll have made good progress or even achieved relicensing at that time. Signing an order to that effect as we speak. I want you to get a reminder copy of that at the window outside the courtroom to your left. We'll see you back here in December, and have a good Thanksgiving, have a good Halloween, and good luck with the license. Take care of yourself.
You're welcome. I believe I think everything I have at the moment. I believe, yeah, no one else is here yet. This is Mr. Mead, but he's just appearing in pro se.
Good morning. And you are Derek Mead? Mr. Mead, your attorney, have you been in touch with Mr. Blandford? Pardon? Ah. I've got the Meads confused, obviously. Sorry. Derek Lee Mead. This is you're on for a kind of a compliance with a diversion hearing. It looks like we need some treatment records, any payments. What's going on with your life? Pardon? Oh, you are? Where? Have you had an eval, an evaluation?
I think so.
No, the payments are another issue. The thing I'm most concerned about is you know, making sure that this doesn't happen again. There's no similar violation of it.
Yeah, I'm not trying to.
You are entering treatment. Have you had who did the evaluation? What we'll need is a copy of the evaluation. What I'd like to do is reset the matter out to, how long are you going to be in treatment? Do you know? That could be a 28-day program. That could be much longer. We don't know. Why don't we reset the matter to November 21st? That's a Tuesday. Let's reset the case to December 7th at 8:15 in the morning. Yeah, we need to have a copy of that on there. And sometimes these. Mr. Mead, sometimes these agencies are really good about treatment and everything, but they're not so good about getting reports to the courts. So make sure that gets taken care of. Reset December 7th, 8:15 in the morning. Sign in an order to that effect. That, to me, that's the least important thing. What I want you to do is follow through with treatment. That's most important. Yeah, payments, that's just one of the details that has to be taken care of. But go ahead, hit the window outside the courtroom to your left, get a copy of the order resetting. And if for some reason, no treatment can be of any duration. If for some reason you're not able to show up in person on December 7th, let us know. Let us know, we can deal with that. Either a remote hearing or just reset it to a date further out. But I want you to, you're going to get out of treatment what you put into it. If you pay attention to it, that's all they can do is put the tools in front of you. But if you want to live a better life, make sure this doesn't happen again. You don't have to listen to anybody lecture you about anything. I'm hoping that you get out of treatment everything that you can. There'll be some people in there that you'll meet in treatment that are just there because they have to be, and you know exactly what they're going to do the minute they get out. But don't be one of them. But good luck to you, Mr. Mead. You take care of yourself. Hopefully we'll see you December 7th. Pardon? 8:15. That'll be on the order. Take care. And I guess with that, we'll go off right. Oh, wait a minute. We have people for the warrant. Okay, let's. Josh Neva. Yeah. Hey, Dan. That's page 6, docket number 2. This is on Zoom. That's one of Josh Neva's. Oh, this is a warrant quash.
Oh,
So
gotcha.
what I
Is that
prefer to
on
do
the,
is
is that on the
reset.
945 or?
That's a 945. Page 6, docket number 2.
Oh, okay. That's the Alwyn, Austria?
Elwin, Austria.
Okay.
Miss Austria, we're going to call your matter now. You're muted. Could you unmute yourself and you're present, but muted. Well, we'll come back to that.
Hi, I'm right here.
Okay, good morning.
Good morning.
It's good to hear from you. Your attorney.
Thank you.
Was Josh Neva. He's no longer with us, but Mr. Haverco, our public defender, is in the current public defender is in the courtroom. I'm going to appoint him to represent you. Your matter is at the pretrial status. So what I'm going to do is reset your court date to, how about November 9th?
That's fine.
We'll be sending you a copy of the order, and you're in treatment now.
Yes.
We'll be sending you a copy of the today's order. It'll have Mr. Haverco's contact information. What I want you to do is give him a call when you get a chance, okay?
Okay, thank you so much.
And if I could just interject, hello there. This is, I am being, excellent. The clerk just handed me the contact information. Thank you for that.
Okay.
I'll be reaching out to you and talking to you about your case.
Thank you.
I hope everything is going well with you in treatment. We're resetting the matter to November 9th. We'll send you the today's order. It'll have the Zoom sign in information on that. If you're not able to appear in person, stay in touch with Mr. Haverco and do the best you can in treatment, okay?
Thank you so much. Thank you so much.
Thank you, ma'am. You take care of yourself.
Thank you. Thank you as well. God bless.
God bless you.
Bye.
Whoops.
This is Lydia Marcela Gutierrez Vega. She is on the 9:45 warrant wash calendar. The matter comes on otherwise, aside from that issue, it comes on before the court also for an arraignment. And
Good morning, ma'am. Is your full name Lydia Marcela Gutierrez Vega? If I mispronounce your name, I apologize. But there's a citation dated September 9th, 2020, alleging that on that day you committed the offense of theft third degree. That's a gross misdemeanor. The maximum penalty on conviction will be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter. He's going to enter a plea on your behalf.
thank you, Judge. I would stipulate to probable cause and ask the court to enter a not guilty plea.
Ms. Gutierrez, a plea of not guilty has been entered on your behalf. I want you to stay in touch with Mr. Haverco, and it's really good that this matter is being addressed. I want to thank you for paying attention to the matter and appearing.
Thank you, Your Honor.
I'm signing electronically the order. Ms. Gutierrez, I want you to get a copy of today's order at the window outside the courtroom to your left. And again, thanks for showing up and addressing the matter. Take care of yourself.
We'll talk.
Mr. Brown, good morning. Dan, we have one more here. Just showed up on computer. Mr. Brown, good morning.
Good morning.
Can you hear me okay?
Yes, I can. Can you hear me?
I can hear you just fine. And your name is Aaron Samuel Brown.
Correct.
Mr. Brown, that's is a review hearing. What we need to have is a copy of any assessment. Where are we on that?
So I'm in treatment. I'm at Adult Teen Challenge, Christian faith-based program. I sent in had them fax over documents to you. Did you not by chance receive that, Your Honor?
Yes, there is. I'm looking at a 2 pages from Life Renewal.
Yeah.
And you're living in their adult residential.
Yes.
Whereabouts is that? Is that?
This is in Renton right now.
And what is the plan long term there?
So I didn't want I had some issues with suicide ideation, so I didn't want to go to just a 30-day program. So I'll be staying here for a few months. And I don't plan on leaving till I feel confident on leaving. So it's at least going to be a few months while I'm here. Yeah.
That's Mr. Brown, it sounds like you're getting yourself on the right track, and that's really good to hear. Sometimes we have to get hit over the head more than once to realize, hey, wait a minute, this isn't working. I need to choose a new career path, so to speak.
And I do apologize, Your Honor. I've been drifting around. I didn't understand. I didn't mean to disrespect the court with the
You don't disrespect the court. I don't want you to disrespect yourself. And it looks like you're past that now. You're in a program that's evidently doing you some real good. What I'd like to do is reset the matter to January 4th. And there'll be Zoom information. We'll be sending you today's order. And if you're still where you are and can't appear in person, sign in by Zoom, okay? I'd like to just see how you're doing then, okay?
Okay, is there anything else that I need to check in with the courts or DOL?
Washed. that's, just need to hear what I'm very glad to hear here is that you're in treatment, you're doing well. That's, as you know, the road to recovery is not a smooth one. It has its potholes and speed bumps and twists and turns. That's just life. It's life.
Okay.
Wish you the best of luck. The warrant is quashed. That's, you don't have to worry about that, but I would like to see how you're doing in January.
That sounds very great. I'll put that on the calendar.
Mr. Brown, you take care of yourself. That concludes the hearing for today. Good luck to you. And, you know, they put it a lot better than I could, but you know, that one day at the time stuff, that there's something to that. Take care of yourself.
Thank you, Your Honor. I really appreciate it. Have a good day.
You too. Take care. Back on record, Mr. Everco, I'm going to defer to you for the order of the calendars called in.
Thank you, Your Honor. So this is Selena Menish. It's item number 6 on the 11 o'clock calendar. Matter comes before Your Honor on a pretrial hearing on a DUI charge. We are requesting a set over. We've filed there's a motion along with a speedy trial waiver in O courts. She needs to complete an evaluation process.
I have the order up in front of me. How much of a set over?
I
If you're in the
asked-
process of an eval, that
Sometimes they take a
takes
while to do these things. I'd ask it to be reset 8 weeks
January 4th.
or December or January, either way.
December 16th, it looks, or 9th, excuse me,
Yeah,
December 9th.
that's fine. Yeah, it should be.
7th, December
7th,
7th.
yeah,
Pearl Harbor Day,
December
I
7th.
should remember that. Ms. Manish, the request of your counsel, we're going to reset the matter out to December 7th. It's these evaluations, they sometimes take a lot of time to complete. December 7th at 11 o'clock, I'm signing an order to that effect at this time. Any conditions of release earlier set remain in effect. Any questions at all? Take care of yourself, and we'll see you back here in December. Now, today's order, as many as you can get a copy of that at the window out of the courtroom and to your left. We'll have the date and time on.
I tried. Okay, all right, sorry. Yeah. Oh, I need to have you. Pay $250. 25 a month. Yeah, sign. I know the fact. This is Eric Cantu, C-A-N-T-U. He's item number 2 on the 11 o'clock calendar. Matter comes before the court for a pretrial hearing on a protection order violation. Parties have reached an agreement, that being a 12-month stipulated order of continuance, the conditions of which are to remain law-abiding for 12 months, pay a $250 probation fee, $25 a month, at the end of which time the city would move to dismiss.
Good morning. Full name, Eric Cantu. Mr. Cantu, I'm looking at the SOC stipulated order of continuance on the screen in front of me. It's an agreement with the city worked out by your attorney, under the terms of which a year from now, the case can be dismissed if you comply with the agreement, which involves, most importantly, staying out of trouble, law-abiding behavior, and there's a $250 cost that goes along with that. Now, in return for the agreement, you've given up your right to go to trial and have witnesses and appeal if you lose. If the city proves a violation of the agreement, we'll have a hearing based on the police reports, and you know what that would result in. It's much better to get a criminal charge, a serious criminal charge dismissed. I'll sign off on the agreement, but all I want you to do is get a copy of that at the window outside the courtroom to your left. Now, read it over carefully, and if have any questions about what it means, give Mr. Haverco a call. I'm going to wish you the best of luck. Some of these situations we get into are easily get out of hand, and the thing is to work past them and get it behind you. I'm going to wish you the best of luck, Mr. Cantu. You take care of yourself. Any questions? Good luck.
You're free to go. Yeah, just go to the, yeah.
That concludes the hearing. Yeah, get the copy.
Cassandra? Go ahead. Your Honor, this is Cassandra Jones.
Cassandra Jones, good morning.
Matter comes on before the court, pretrial hearing on assault 4-3 charge. Parties have reached an agreement proposing the court accept a stipulated order of continuance. There's one in Oak Courts.
Have it in front of me.
Conditions of which are remain law abiding for 12 months, pay a $250 probation fee. She's just got a job, so she had a question about payments, and I said, well, I don't think the court would set the first payment due until next month, so she'd have enough time to get, hopefully get a paycheck by then, at the end of which time the city would move to dismiss.
November 26th, be a good date for the, okay. I'm going to repeat a lot of what I just said. I pretty much have to do it. Make sure you understand. It's an agreement between you and the city, worked out by your attorney, under the terms of which this charge can be dismissed, which is a good thing. There's a gross misdemeanor. You could go to jail for up to 364 days. And the conviction on your record would not help at all. You abide by the agreement, the charge is dismissed, it goes away. But if you violate the agreement, having given up your right to go to trial, have witnesses, you violate the agreement, we'll have a hearing based on the police reports. That would result almost certainly in a conviction, and we don't want to go there. You have a chance to get this charge dismissed. I know domestic situations are difficult to deal with, I realize, and all that high emotion that runs, but you have a chance to get this behind you with nothing on your record. I'm going to wish you the best of luck. And once again, what I want you to do is get a copy of the agreement at the window, read it over carefully, and if you have any questions about it, give Mr. Haverco a call. Any question at all? I appreciate you saying that. And now what I want you to do is make sure this is a lesson well learned and not to be repeated. Yep. No, you just have a good one. Thank you.
Just go to the window before you go. Thank you, Judge. So the next matter is going to be Mr. El Haji, I think Mabengi. It's item number 4 on the 11 o'clock calendar, comes before the court on a pretrial hearing for a DUI charge. Parties reached an agreement. He's going to enter a straight plea to the charge of DUI, amended to that of no test, to reflect to be no test. And the city would be recommending the mandatory minimums.
Good morning, sir. I'm not going to insult you by mispronouncing your name, which I'm sure I would do if I tried it. How do you pronounce your name? Thank you. Is that your true and correct name? That's it. I'm looking at a statement of defendant on plea of guilty to one count of driving while under the influence of intoxicants. Plea form tells me you're 57 years of age. Have you gone over the plea form and the process with Mr. Haverco? And if you had any question at all about what it meant to plead guilty, was your question answered?
Well, he has some paperwork having to do with installing an ignition interlock device, which is, it's
Department of Licensing.
Department of Licensing.
That is something that I really don't have anything to do with. That's the Washington State Department of Licensing imposes those. I can't suspend your license. They suspend your license. I can't order you to get ignition interlocked or make that a condition of driving. That's something the Department of Licensing takes care of. All I can do, I can order you to, don't drive unless you're equipped, if you're ordered to equip with ignition interlock by the department. That's all I can do. Other than that, I have nothing to do with it. But DUI is what they call a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine, which I'd be free to impose. Now, if I accept the plea, the Department of Licensing will suspend your license for a period of time in accordance with a what your record is and what this conviction is for. It's, I understand, a conviction with a stipulated no test result. Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. You understand that? Okay. With that in mind, as to one count of driving while under the influence of intoxicants in Yelm on September 22nd, 2023, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty?
He's asking, has anyone made any threats or promises to you to make you plead guilty? Any promises other than the city's recommendation? The answer would be no.
I will find the plea to be freely, knowingly, and voluntarily made, and the statement in paragraph 11 does satisfy the factual elements of the offense. Can't have people pleading guilty to something they didn't do. That's it. Now, the recommended sentence is what they call the standard first, as I understand it.
He has priors, but they're outside of the 7 years.
Outside of-
So he has
outside of the
no priors in the last 7 years. So, and with a no test, it would just be the mandatory minimum, 1 day, $990.50 fine.
Is there anything you'd like to tell me about the recommendation, about what happened? Anything you think I should know? Now, this is kind of a bitter pill to swallow, but let me first ask Mr. Ratfield, does the city have anything further to add? No, I'm going to follow the recommendation, 364 days in jail, 363 of those days suspended on the conditions that I'll go over in a minute. That leaves 1 day to serve. Is there any sort of recommendation as to alternate?
Well, I don't think there's really any alternate available anymore.
That is sometimes the
And I'm trying to
case.
remember, did you put it? He thinks he spent 24, he thinks he's.
I'm going to give him credit for time. I'm going to give you credit for 1 day served. That leaves 363 suspended on some conditions. Don't drive unless licensed and insured, and don't commit criminal law violations. Most importantly, don't drink and drive. Don't do that. That's I'm familiar with too many circumstances where people never made it to a courtroom because they died as a result of drinking and driving. Yeah, that's the important thing here. And as well, it's you don't want the guilt of having killed somebody, which would be something you'd never think about doing if you hadn't been drinking. That's what we have to do is learn to completely separate our drinking from driving. You do one, don't do the other. That's now, as I indicated, the Department of Licensing will be taking action against your driver's license, and of course that kicks in insurance requirements, and as you indicated earlier, ignition interlock requirements. What I want you to do is learn from the experience, and it's been a while, but I don't want you to repeat it. Okay? Any question at all?
Yeah. Oh, he had a question about the bail, Your Honor. I would assume obviously any bail posted would be exonerated. and
Yes.
returned to the
Oh, yes.
poster.
The bail is automatically exonerated. Was that a bonding company that posted that?
I think he thinks
They'll
it
be-
was a friend, he thinks it was a friend who posted.
That if it was posted as a cash bail, that'll be returned to whoever posted it. If it was a friend, have them contact the court and as to when they can pick that up or have it mailed to whoever it was. But yes, the bail is exonerated. Sign the judgment and sentence.
Well, before you leave, go to the window and get a copy of the judge's order. And in there, there'll be probably a deadline within which you have to probably get an evaluation and show proof and,
The two things I didn't mention was I will impose, I have to impose a $990.50 fine in the matter. You can pay that at the rate of $50 a month, starting first payment on November 26th. Also, you're required to get a drug and alcohol evaluation and comply with any recommended treatment. You can do that through any state certified treatment agency, but I'll require that you do that within the next 120 days, no, 90 days. If that should be enough time. If it's not, let us know. I'm going to wish you the best of luck. You take care of yourself, and as life goes, if we don't learn from our mistakes, we're condemned to repeat them. And I'm hoping that you've learned from this.
and Judge, then was it also 90 days for the victim impact panel as well?
Of course,
Okay.
90 days to complete the requirements of victim impact panel and drug and alcohol evaluation.
And before you go, if you have any more questions, you could also talk to the clerk. She'll give you the paper. Yeah. So just when you exit here and take a left. Yeah, you're free to go.
Okay, that's all. We will. Good luck, sir.
Ms. Shalhoub?
Morning, ma'am.
This is Sarah Faye Shalhoub. She's on the 9:45 warrant
Yes.
flash calendar. And
Well, it's substantially past 9:45. Ms. Shalhoub, good morning. So I guess the question is, what do we want to do?
well, this I assume would be her first appearance after failing to appear, so a speedy trial would start anew. I guess I would ask to, set a new pretrial hearing, and hopefully I'll be able to have a chat with Ms. Shalhoub about her case.
There's two matters. You're on an SOC. No payments have been made on that at all. You're also scheduled for a pretrial hearing on a criminal trespass charge. And also, you need to show up for court on time. That's always a good idea.
I was gonna ask you, do you have a current phone number that works, or what is it? 236? 226.
But how far out do we want to set this?
Just kind of ordinary course.
Okay, November 9th.
Okay. Go ahead and sign here. With what, the crime itself? Well, no, that's not, that's not really for this morning. Great. We'll talk about it. Okay. You know, the trespass? Well, we'll talk about it. Now's not a good time. I'm gonna go meet with Mr. Rosnick. He got some of the phone number, so I can't speak out with him. Rosnick.
Ms. Shalhoub, the warrant is quashed. You need to stop at the counter and get a notice of the hearing set for November 9th, 11 o'clock. Please be here by 11 o'clock, okay? That concludes the hearing. You can get a copy of the notice, and we'll see you back here in November.
And good morning, Your Honor. Before the state has an opportunity to leave the courtroom.
Good morning. Yeah, unfortunately, I couldn't grab Mr. Ratfield before he ducked out on me.
Yeah, I see that.
Ah. Draft.
Thankfully, I'm only here on one matter, but I understand state's presence is necessary.
Okay, go ahead.
And Your Honor, for the record, Seth Taninga of Puget Law Group on behalf of Attorney of Record Ms. Gina Buskirk on the Jason Turner matter. That is case number 3A01-88277, 278, and 279. We're requesting this matter be set over to December 7th at 11 a.m. There is a speedy trial, or there is a motion to continue and a speedy trial waiver already uploaded to courts.
I'm signing the order, resetting the matter to December 7th. As we speak, attaching my signature to it at this time, and that concludes the hearing. Matters reset to December 7th. We'll send you and Jason Turner a copy of the today's order.
Oh yes, and I forgot to mention I am appearing on my client's behalf pursuant to Rule 3.4. Thank you for the reminder, Your Honor.
Okay, thanks a lot. You take care. Have a good day.
You as well, Your Honor. Thank you.
Michelle, thanks. Back on record. Mr. Haverko, I'll defer to you.
Thank you, Judge. Go ahead and sign on it. So this is Cyrus Brosnick. He originally had 3 matters that were to come before the court for pretrial hearing. I can see there was another matter added that's an arraignment matter. And in an effort to sort of deal with all these cases at the same time, I've submitted a motion for continuance with a speedy trial waiver in O courts on the 3 pretrial matters, with the idea that in anticipation the court would likely appoint me on this new matter, and then we would hopefully could then set all 4 of those matters at the next convenient date.
For the record, your full name is Cyrus, middle initial J. Rosnick. You are here also for a arraignment on 1 count of theft third, alleged to have occurred on September 27th. Theft third is a gross misdemeanor. The maximum penalty would be $364 and or $5,000. I'm going to appoint Mr. Haverko to represent you on those cases as well. He'll enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate to probable cause as the court to enter a not guilty plea on that new matter.
Plea of not guilty preserves your rights, as you know, and pending a pretrial, which we'll set for November 9th. Now we have cases filed alleging violations on September 18th, 17th, 24th, and now 27th. Mr. Rosnick, on each and every one of those, a condition of release was law-abiding behavior. There are some judges that would have you taken into custody at this time and say, hey, the only way of keeping you out of trouble and amenable to the judicial process is set bail. I'm not going to do that, but I am going to remind you that law-abiding behavior is important for future cases, but also important for any possible resolution of these cases. Cases are set for 10 o'clock, November 9th. We'll see you back here. I'm hoping we see you back here in person as we do now. And I don't have to call the Squally jail to decide whether you're to be released for court or not. I don't want to do that. What you need to do is talk to Mr. Haverko about that, and if there's anything to look into, he can do that for you. But yes, sometimes the left hand is not aware of what the right hand is doing, so to speak, and things happen. What happened here exactly? Off the top of my head, I can't give you an answer, but that is something that can be looked into. Mr. Rosnick, you can get a copy of today's order, and I want you to do that at the window. November 9th. That's 2 weeks from today, and there's nothing sooner. We don't have anything sooner. Order on your arraignment and an order continuing the pretrials available for you at the counter. Stay in touch with Mr. Havercode. We'll see you back here 2 weeks from today.
Yeah, pretty good.
Mr. Rosnick, thank you for appearing. Take care of yourself. Computer dinosaur. Well,
If we could, one matter.
given
if
the
we could-
time, but let's,
So on the 10 o'clock calendar, item number 1, Austin Barker, that's a matter to remind the city was going to move to dismiss on that. That's the fellow that had some paperwork to show he was in Minnesota or something like that. I don't know if that. So, yeah, based on the city's, I had sent some materials to the city was satisfied and advised me that the defendant didn't need to be here for that because they were going to dismiss.
Dan, can you remind me what the defendant's name?
It was, I'll jog your memory. So it was a hit and run and there was a witness that said they saw a certain car.
Oh, no, I remember all of that.
Oh, okay, yeah.
I'm just trying to find it on the docket.
Oh, it's number 1 on the 10 o'clock?
Okay.
Unless it was already removed. I'm looking at the draft.
Did I,
Is that on
Barker,
there? Okay. Yeah, it's Austin Barker.
that's it. Page 8, docket number 1,
yeah, I found it. Okay.
Austin Andrew.
I'll, oh, yeah. Okay, I'll, put together the, order of dismissal now, but yeah, the city's dismissing this.
Motion to dismiss, granted.
Yeah.
You want to do an order now or
Yeah, I'll do
later?
an order now,
Okay.
so-
Got it.
And
Got it
Next.
and signing it.
next 2 matters on the 10 o'clock, there was James Anthony Bittner.
Yes.
You know, I have had contact with him. We did have a telephone conversation and I had anticipated submitting a jury trial waiver to set in for trial. So I don't have any information and he hasn't contacted me insofar as his non-appearance today. So we probably spoke maybe last week just about the case. So I had anticipated him being here, but he hasn't indicated me or given me any information as to his non-appearance.
Docket number 3, the charge for which he's posted bail. I thought that was fairly concerning. No idea why he isn't here.
No, you know, like I say, we discussed the case on the merits and so I had every anticipation and belief that he would appear today and he hasn't called me since we spoke last week, so he hasn't reached out to me as to why he wouldn't be here. I have no information.
Well, he has bail posted 25, forfeit the bail with notice and reissue the warrant, 25,000 cash or bond. That would be on docket number 3. 2,500 each on dockets 2 and 4.
And the next no-show I have is a Julia Kristen Carcamo. I haven't had any contact with her because I have made a note to myself that when she was in court on her arraignment, she did not have a phone. So I haven't had a way to contact her. I was hoping she would be here so I could meet with her in person today.
As I remember, the case was one of a child that was allegedly walked away from at the grocery store. Some cases have an obvious mental health component. I'm inclined to issue a warrant. 2,500 cash or bond. That's
And on
Gerald Christopher.
yeah, Gerald Christopher, again, at the arraignment, he did not have a number. Or actually, no, he gave me a number, but the number is no good. So I called the number, was non-functioning, so I've not had contact with him.
1,000 cash or bond.
On the, seeing on,
Dave Lipscomb.
Yeah, Dave Lipscomb, I had contact with him, talking about the cases, and had an anticipated resolution. I had placed a statement of defense on plead guilty in Oak Courts, so I did anticipate him being here, but we spoke last week, just like with Mr. Bittner. He told me he was going to be here, and he hasn't provided me with any updated information as to his non-appearance.
Ordinarily, I'd be inclined to reset it since you've been in touch with him, given the nature of the offenses. However, we can do that, but we'd be obligated to send to the bonding company a notice that if his unexplained failure to appear, I think is the statutory language. What other choices to issue a warrant and forfeit bail? City so moves, will do. And I think, yeah, 2,500 a case. Brings us to 11 o'clock, which docket number 1, there's a entry that he is Mr. Dillon. Cody Katie is in custody in Issaquah. Their Muni court up there.
Yeah, I assume so.
And there's a
And when
release.
was there a note as to his release date?
3/10/24 is his
Do
he must have offended
Other than knowing where he is in jail. do we
the
have
judge is a pretty good.
Do we have a good
Well-
address, set a notice for April?
Well, we learned earlier today, we can't, Oak Courts won't let us set out that far. But I think we can't go past January 4th. What we could do is issue a very low bail administrative warrant, 1,000 cash or bond, just to preserve jurisdiction and see what happens. A lot water will go under the bridge between now and March. It's a warrant, 1,000 cash or bond.
I think that's everything.
Because Jason Turner did appear, and that was reset to December 7th. Good afternoon. We're going to call the 1 o'clock arraignment calendar. Before I call you up one at the time, I need to advise you, you do have a right to have a lawyer at each stage of a criminal proceeding. If you can't afford a lawyer, if you're indigent, I will appoint a lawyer to represent you throughout the course of your case. Typically, at the arraignment, a plea of not guilty is entered, which preserves your rights pending a pretrial. That's a chance for you to talk to your attorney and your attorney to talk to the representative of the city who's seated over here to my right. If you can work out a mutual agreement of your charge, that is put on the record. If you can't do that, you do have a right to a public and speedy jury trial in the county where the offense is alleged to have been committed. If you have any question about your rights or what you're charged with, either ask Mr. Haverco, our public defender, or myself. Melissa Baker in the courtroom. Ms. Baker, if you'd step forward and have a seat. Now, what I'm going to say to you is going to apply to other people in the room. You were cited where the offense of driving a license suspended or revoked in the 3rd degree. That's a misdemeanor. Maximum penalty is either 90 days in jail or $1,000 fine. The city will very likely amend the charge to the civil infraction of no valid operator's license on your person. City so moves. What that means is there's no possibility of any jail time. If you admit the violation, I'll impose a fine in the amount of $150. If you deny it, we can set it for a contested hearing. Any question about anything I just said? Do you admit or deny the infraction? I will assess a $150 fine, which you can pay at the rate of $25 a month. Question I have is, do you know what you need to do to get your license reinstated? Money and time, money and time. I want to encourage you to do what you can to reinstate your license. I'll say for the last time today that we live in a world where you pretty much have to be able to drive, so you need to get relicensed. I'm signing an order to that effect, Ms. Baker. And I'll say this to everybody, when your hearing concludes, what I want you to do is go to the window outside the courtroom to your left and get a copy of today's order. It's review it carefully, and if you have any questions, give Mr. Haverco a call. If you're set for a pretrial, his contact information will be on the form. Baker, thank you for appearing. Good luck getting reinstated. Any questions? Take care of yourself.
Yep.
If you have trouble making the fine payments, make sure you get in touch with us. We don't want the case to go to the Department of Licensing as a failure to appear. Good luck to you. Ronald Carby. Carby does not appear. How about Lauren Corsini? We're going to interrupt a little bit here to take a Zoom hearing. Ms. Langley, good afternoon. You're muted. Your client, Jamie Carrot, is also here by way of Zoom, but also muted. Could both of you unmute? Ms. Langley, I'll need you to unmute so we can have the hearing. Thank you.
I think I have it now, Your Honor. So I apologize. I inadvertently told Ms. Garrett she could appear by Zoom. I see now she shouldn't have.
No, she's here on Zoom.
Oh, yes, my error. So
Good afternoon, Ms. Garrett. Is your full name Jamie Lynn Garrett? You've remuted yourself. Could you unmute yourself? Thank you. Is that your full name?
Yes, Your Honor.
Ms. Garrett, the citation alleges that on or about October 13th, 2023, you committed the offense of DUI, driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. At this point, I'm going to turn to your attorney, Ms. Langley, for the entry of a plea in your case.
Thank you, Your Honor. I've had an opportunity to review my client's rights and these charges with her without any further reading. We will stipulate the probable cause for the purposes of release conditions only, enter a plea of not guilty.
A plea of not guilty has been entered on your behalf, which preserves your rights. We'll set the matter for a pretrial with your attorney at this point. Ms. Langley, how about December 7th or 21st? 9 a.m.
I think December 7th will be fine, Your Honor.
Ms. Garrett, we're setting your matter for a pretrial on December 7th. The conditions of release are law-abiding behavior, stay in touch with your attorney, no drinking and driving, and no driving without license and insurance. Any questions?
No, Your Honor.
That concludes the hearing. Ms. Garrett, again, stay in touch with your attorney and we'll see you back here in December.
Thank you.
Thank you, Your Honor.
Call a case out of order in the back of the courtroom with the child. We'll take your case now. If you would identify yourself by name. Last name Mitchell. Full name Ryan, middle initial J, Mitchell. Mr. Mitchell, you were cited with driving a license suspended or revoked in the 3rd degree. And bearing in mind my remarks earlier, the city may have a motion with regard to your case.
Yes, Your Honor, city moves to amend to no ball in the 2nd degree.
Any question about what just happened? The charge is now a civil infraction, driving without a license on your person. All you can do is have to pay a fine if you admit the infraction. If you deny it, we can set it for a pretrial. Any questions? Do you wish to admit or deny? I'll assess a $150 fine, which you can pay at $25 a month. If you can't make the payments, let us know. That we can deal with. Do you know what you need to do to get your license reinstated? That's as I did a moment ago, I urge you to follow through on that. Signing an order, doing exactly what I said. Mr. Mitchell, I want you to get a copy of the order at the window outside to the left, and that'll conclude the matter, and you take care of yourself. We'll try again, Ronald Carby. Lauren Corsini. We're up to Justin Davis. Mr. Davis, I saw you walk in. Come on up and have a seat if you would. I'm glad you appeared. For the record, your name is Justin, middle initial B, Davis. Mr. Davis, the citation alleges that on or about October 7th, 2023, you committed the offense of criminal trespass, 2nd degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Based on your financial circumstances, I'm going to appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor, ask the court to enter a not guilty plea.
Mr. Davis, a plea of not guilty preserves your rights pending a pretrial. Conditions release are law-abiding behavior, stay out of trouble, and that includes don't drive unless licensed and insured. Pretrials for December 7th, 10 o'clock in the morning. In the meantime, stay in touch with Mr. Haverco. Mr. Davis, any question?
see the clerk before you take off.
Davis, get a copy of the order at the window and we'll see you here in December. Michael Dettert does not answer. Anybody on for Joshua Eastman? Nobody. It sounds like. Well, we know how that turned out. How about Kimber Faith? Kimber Faith in the courtroom? Does Faith come on up and have a seat if you would? Good afternoon. Full name, Kimber Marie Faith. Faith, thank you for appearing. Citation alleges that on or about April 30th, 2021, you committed the offense of theft in the third degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf. He will represent you throughout the course of the case if you're indigent and request his services. Mr. Haverco?
I think Your Honor would stipulate to probable cause as the court to enter a not guilty plea.
Ms. Faith, a plea of not guilty has been entered on your behalf. I'm glad we're at last addressing the matter. We'll set it for pretrial. In the meantime, conditions release, of course, are law-abiding behavior. Stay in touch with Mr. Haverco and we'll see you back here on December 7th at 11 o'clock in the morning. That'll be your pretrial date. Now, I'll sign an order electronically, of course, after you sign the same.
Yeah, it won't show it, but it's working. And, do you have a phone number?
Hey, thank you very much. When you're done exchanging contact information, get a copy of the order at the window, and we'll see you back here in December. Good luck. Sandra Coral Ray Fankel does not respond. How about Paige Franzak? Good afternoon, ma'am. Is your full name Paige Brooke Llewellyn Franzak? The citation I have alleges that on or about October 22nd, 2023, you committed the offense of assault in the fourth degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction to be 364 days incarceration and or a $5,000 fine. I will appoint Mr. Haverco to enter a plea on your behalf, and he'll do so at this time.
I think Your Honor would stipulate to probable cause as the court to enter a not guilty plea.
Ms. Franzak, that preserves your rights as I indicated earlier. We'll set the matter for a pretrial. Conditions of release, as earlier said, they'll contact with Mr. Rosnick, stay out of trouble, and stay in touch with your attorney and appear for court as directed. Any questions? What's your position with regard to no contact? I think, given the circumstances of no hostile contact. I've heard that it's not very clear what that means, but basically I've heard it described as well, if the police are called because there's a dispute, you're the one that's going to go to jail. So yeah, no hostile contact. Once again, December 7th, 10 o'clock is your pretrial date. Navia Johnston does not answer. How about Andrew Lee Cocott? Mr. Cocott, come on up and have a seat. Excuse me, I should indicate that I grew up with 7 very noisy brothers and thought I was immune to childhood noise, but that turned out to be a bit of a distraction today. Good afternoon, sir. Is your full name Andrew Lee Kokot? Citation alleges that on or about October 17th of this year, you committed the offense of theft 3rd degree. It's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. With that in mind, I'll also appoint Mr. Haverco to enter a plea on your behalf. Mr. Haverco?
Stipulate to probable cause, Your Honor. Ask the court to enter a not guilty plea.
Plea of not guilty noted for the record, preserves your rights pending a pretrial. Mr. Kokot, conditions to release, of course, law-abiding behavior, stay out of trouble. Stay in touch with Mr. Haverco. Exchange contact information with him.
Before you go.
December 7th, 2023 at 10 o'clock will be your pretrial date.
Sign it.
Kokot, thank you. Stephen Morris in the courtroom. Full name, Stephen Michael Morris. Mr. Morris, you were cited with the offense of driving no license suspended or revoked in 3rd degree. City may well have a motion in your case. Mr. Morris, if you listen to what I was saying earlier, charge is no longer criminal. It's civil in nature. Being civil in nature, there's no jail time. If you admit that you committed the infraction of no valid operator's license on your person, I'll assess a $150 fine and that'll conclude the matter. Any questions about anything I just said? What do you wish to do? And I'll ask you the same question. Do you know what you need to do to reinstate your license? I'm going to urge you to do that. I realize it takes time and money in most cases, and it's hard to earn a living when you're not allowed to drive to work, to do just that. I'm going to wish you the best of luck. Take care of yourself. If you can't make the payments, let us know and we can certainly deal with that. The way I handle it is this. I'll initially set it at a $150, a $25 a month, first payment due November 26th. Now, if it's possible for you to do that, let us know. We'll reschedule the matter for a hearing on just how to handle the payment. Here we are adding to the misery of that you're already in, but I have found out that people, after trying community service, find that it's much easier to generate a couple of dollars to pay towards their fine. I'd like to see you try that first. Good luck to you. Again, get a copy of the order today and look it over carefully. Lena Ortega. Good afternoon, ma'am. Is your full name Lena Wainani Mako Ortega? If I apologized I apologize for mispronouncing your name if I did that, and I'm almost bound to determine that I'm going to do that. The citation alleges that on or about October 16th, you committed the offense of assault in the 4th degree domestic violence. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate to probable cause and ask the court to enter a not guilty plea.
Ms. Ortega, plea of not guilty has been entered on your behalf, as I indicated before. That's preserves your rights pending a pretrial. Conditions of release are law-abiding behavior, of course, and there's also a concern with contact with Damian Cadigan, the alleged victim in the matter. Is contact with him any problem at all? No hostile contact. will be- They got pretrial set for December 7th, 11 o'clock in the morning.
It's early. Yeah. It's a legal meeting. He's not a party. You are. Yeah, this is the witness.
Jacob, thank you for appearing. Again, don't forget to get a copy of today's order. You take care of yourself. Eduardo Pineda Cortez. Good morning, sir. Is that your full name? The citation alleges that on or about October 14, 2023, you were a driver in consumption of alcohol being less than the age of 21. Gross misdemeanor, the maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Pineda Cortez, a plea of not guilty has been entered on your behalf. Again, that preserves your rights pending a pretrial. Stay in touch with Mr. Haverco while the matter's pending, and don't drive without license and insurance. And given your age, no drinking and driving at all. Any question at all? Oh, no, that's when I arraign somebody, I'm required to advise them as to what's the worst that can possibly happen. I would say the chances of you going to jail for 364 days on this charge are about zero. This is something you need to talk to Mr. Haverco. He can advise you on how these cases usually proceed.
Sign here. It's working.
Any questions, sir? That concludes the hearing. Don't forget to get a copy of today's order, and we'll see you back here in your pretrial date. Okay. Good luck to you. And you as well. Is Paul Reed in the courtroom? Paul Reed. How about Matthew Robinson? Good afternoon, sir. Full name Matthew Thomas Robinson. Mr. Robinson, your citation was for driving a license suspended, revoked, third degree. By now, you probably know what's going to happen.
Yes, city moves to amend to no bonus.
No longer criminal. It's now a civil infraction. Most I can do is impose a fine. Typically impose $150. If you admit it, if you deny it, you're entitled to a contested hearing. Any question about the process? What would you like to do? 150 it is. And again, you know what I'm going to ask you. Do you know what you need to do to get your license reinstated? We live in a world where you got to be able to drive. That's so I'm trying to convince you to, do what you can to get it reinstated. Signing an order to the effect of what we've done today. And again, if there's trouble making the payments on the fine, make sure we know, and then we can deal with that pretty easily. But good luck to you. Take care. Thanks for your patience, and have a good day. Thank you, sir. Stacy Skartvet. How about Zana Trapp? Good afternoon, ma'am. Full name, Zana, middle initial D, Trapp. Ms. Trapp, the citation alleges that on or about October 21st, 2023, you committed the offense of assault in the 4th degree DV, domestic violence. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'm going to appoint Mr. Haverco to represent you for today's hearing and throughout the course of the case, should you be indigent, then that is your wish.
Thank
Mr.
you, Your Honor.
Haverko?
Would stipulate to probable cause and ask the court to enter a not guilty plea.
The not guilty is entered on your behalf, ma'am. We'll set the matter for a pretrial. And again, there's always the no contact issue that arises. Is there any problem with regarding contact with Zachariah Bocock Trapp? Well, the order will be no hostile contact, and that puts the burden on you to make sure things are proceeding in a peaceful fashion. And like I said earlier, no hostile contact means that if there is a problem that the police are called, you'd be the one to go to jail. That's just how that works. Any other questions? Good luck to you. Set the matter for a pretrial. That'll be December 7th, 11 o'clock in the morning. Thank you. So, Kenneth Wood. Good afternoon, sir. Thank you for your patience. Full name, Kenneth Raymond Wood. Mr. Wood, the citation I have alleges that on or about October 16, 2023, you committed the offense of assault in the 4th degree DV. Once again, gross misdemeanor, the maximum penalty on conviction to be 364 and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf. We'll do so at this time. We'll set the matter for a pretrial.
Thank you, Your Honor. Stipulate to probable cause, ask the court to enter a not guilty plea.
Plea of not guilty preserves your rights pending a pretrial, which will be on December 7th at 10 o'clock. I'll sign an order to that effect. Conditions of release, of course, are law-abiding behavior, no contact if that's been provided for. Any questions about today's hearing? Yes, it will be. And as I indicated earlier, no contact is a rather incapable of precise definition. What it means is if there's a problem, then the police are called. Guess who's going to jail?
You need to sign this. And we have a phone number. 9326.
Good, thank you. Take care of yourself. Don't forget to get a copy of the today's order. Sir, I'm out of files, but I'm not out of people, evidently. I didn't see you come in late. If you identify yourself for the record, we'll deal with your matter. Last name? Mr. Bittner, you were here, that's from this morning.
Right.
You had a pretrial set for, I forget, 10 or 11.
No, 1 o'clock is for arraignments. So yeah, pretrials are 10 or 11.
This one was
So
set
do
for
we
10.
wanna?
No, that happens. Mr. Bittner is here. I had ordered a forfeiture of your bond and a warrant for your arrest, but you're here. We can deal with that, I believe, at this time. Yeah, it's important, A, stay in touch with Mr. Haverco to confirm. Make sure you know when you're supposed to be here. And B,
Question, my question for everybody, do we want to proceed with the pretrial today, or do we want to, based on the FTA, do we want to reset it, or what?
I'll defer to you.
I'm fine proceeding today.
Okay,
Sure.
so,
If you want, ma'am, you're here for court? Pardon? Oh, okay. This is what I want you to do at this stage. This is the gentleman you need to talk to. This is Mr. Ratfield. He's the city prosecutor. If you have input in the case, this is the person you should talk to.
the court would just give me a moment. So we have put into Old Courts a waiver of jury trial and want to have the assault case, and might as well just to wrap it in and make it simple. The suspended driving third case also set at the same time. They're unrelated, but
I'll defer to the parties.
I don't know.
You're asking for a bench trial here?
Yeah.
That was
So I guess.
there
I
being no
guess-
jury, I'm
I guess-
willing to hear both at the same time. If it was a jury trial, I would say no, they've got to be bifurcated. But
Right,
if it's a
right.
bench trial,
Right.
that's I have no problem with that.
So I guess technically our speedy trial time starts today.
Yeah, the next thing to work out is I'm going to suggest a 2 o'clock start time for a bench trial.
Yeah,
I think
yeah,
we
I
had,
know sometimes we talk about maybe doing one over lunch, but I think you're.
sure, we can do it that way.
But I mean, 2 o'clock might be better because good to have kind of a break.
Ordinarily have a 2:30 infraction calendar, but we can see what's available.
Yeah, I
Sure.
think we should, I think,
That'd
you
be-
know, I
that'd
think
be a
we
good
should,
idea.
I think we should do a readiness trial confirmation and then a trial.
Mr. Bittner, usually what we do is set two hearings. Going to trial on a case is it's crossing the Rubicon. And very often there's last minute thoughts about the wisdom of, hey, let's work out something that everybody can agree to instead of going to trial and get some result that nobody likes. And I've inflicted that on people before. So we set it for a readiness hearing, and that means all the pretrial issues, any motions to suppress are dealt with and handled, and people have their witnesses on tap and they're ready to go for trial. So let's set a readiness hearing for,
And I, by the way, I calculate the end of speedy trial to be 124.
let's set a readiness hearing for next week. Is that too much time or not?
Oh, for
enough?
readiness?
Just for readiness.
Uh,
And then we can figure out what the date for a trial is then.
sure.
And that'll give my clerks time to
Sure.
find out what.
Oh,
it
yeah,
is.
oh, yeah. Yeah, sure.
November 9th, 11 o'clock, I have a pretrial readiness hearing. Signing an order to that effect at this time.
It'll be on the paper for you.
And I'm going to suggest if there are any issues regarding motions, let me know ahead of time.
Sign the wrong. Okay, sign amendment. Sorry. I clicked on the thing. See if I-
Now, I have no idea what kind of a witness
Well,
is there going to be
we,
called, but perhaps
yeah,
council
we'll talk.
could confer together about
Yeah.
how much time is going to be needed for trial and we can set it accordingly. Fair enough?
Fair enough.
Mr. Bittner, that concludes the matter. A copy of today's order at the window
Judge.
out and with that, I guess we'll go off record. Take I have a write-in mitigation hearing. That would be number 2 on page 19 of today's docket. Brian LaHue cited for MDOL with ID and no insurance. Enter a finding, reduce it to 150 each infraction, and we'll send Mr. LaHue an order reflecting that fact. Maybe change that to 25. Good afternoon, sir. Are you here for a traffic case? Okay, yes. Are you Mr. Ulapig? Okay, got it. We'll take your case next. Mr. Ulapig, come on up and have a seat, and we'll take your case. My clerk is bringing in the files, and it's when she does that, we'll take your case. Come on up and have a seat. Yes. You bet. Right there. You bet. Good afternoon. Your full name is Arturo Fernando Umapig? Yes. You were cited for speeding in the school zone and also no insurance. And you wanted a contested hearing?
I came here to
Hey. Yes.
And I kind of want to be happy. Very slow way that I was going through the fire. I do that all the time. If I did, I don't.
But okay, that takes care of the school zone ticket. How about the insurance? Oh, do you have that now?
Yes, I do.
Can you show it to me? No. You did have insurance at the time. Now, what I'm going to do is on the school zone ticket, there's a technical reason I'm going to dismiss that. I don't need to go into that. With the speed measuring device, there has to be a 6.6 affidavit in some way of verifying the accuracy of the whatever speed measuring device was used, and that's not here, so I'm going to dismiss that. And now on the insurance tickets, if somebody actually did have insurance, but they just, for some reason, couldn't show it, I'm allowed to assess $25 in costs and dismiss the ticket. So that's a little better than than $864. Oh,
It's nice.
it is nice.
Yeah, I'm going from Seattle.
Oh, you came in the right direction. Seattle's gotten horrible.
So when I got a ticket.
Okay, With that, 25 is a lot better than 864. Hey, thank you. Happy driving, and the reason why in school zones are real careful about that. It's so easy to cite people for that, but the worry is about, kids. They'd race across the street without looking either way, and that's that. But hey, Mr. Ulvig, thank you for appearing. You take care of yourself and have a good day. The 25 buck they don't trust me with money. So you have to go to the window outside of the courtroom and over to the left, and she'll take you 25 bucks. If you want to pay it today, you need some time to take care of that? Okay, your choice. Oh, hey. Oh, hey. Subic Bay. You have a great day and have a safe trip to the Philippines and back. Have a good one. Back on record for the 1 o'clock no-shows. I go to page 15 of the docket. First no-show is Ronald Carvey, DLS third. FTA, a Noval 2 ticket amended down from DWLS. Same way with the next one, Lauren Corsini. That's a reset request in there, so just reset that with notice. And after that is Michael Dietert. Violation of a no contact order. I find probable cause for the issuance of that and did so back when I arraigned him or spoke to him in custody on October 13th. 2,500 cash or bond. He was scheduled to be here, assured me he would be here that date, but not so. Next would be Joshua Eastman. My own motion dismiss that charge due to Mr. Eastman's incompetence found on previous occasions. Next is Sandra Franco. I found probable cause for the issuance to her of theft third and crim trust 1 on October 16th when she was released on her promise to appear. Today, October 26th. $2,500 cash or bond. Next would be Navia Johnston. That's docket number 12. She's cited for NVOL without. Amend that to with, and FTA that to the Department of Licensing. And that brings us to Paul Reed. Find probable cause for the issuance to him of a criminal trespass first degree citation on October 13th, 2,500 cash or bond. And that I believe, no, one more, Stacy Skartvet. Hey, Dan. Go, Dan. Well, they can't do it. That leaves us Stacy Skartvet. All okay with this, Jared? I talked to her on the jail. This was the second time she's been in on a warrant. She has 101 items on her criminal history, and she's 60 years old and obviously does not really know when she didn't know where she was or why she was there and thought this might have been. That's Garrett, actually. Here. Oh, start again. Garrett, doing the warrants. 1 o'clock case, page 18, Stacy Skartvet. Oh, she's was cited for theft third. She was in custody this last week. She's 60 years old. She has 101 items on her DCH. She hardly knows where she is. She wasn't sure why she was in jail. And she's on the edge. She will never get her here. Dismiss. That's my 100 thought. 101. Here, let's wow. Dan, if you're out of, you take care. Good afternoon. I see we have somebody is appearing for on behalf of Mr. Gargoyle.
I am, Your Honor.
Ms. Gallagher, good afternoon.
Good afternoon.
Mark Vincent Buban,
Yes, I am here on that matter.
and I have read the 1, 2, 3, 4, 5 line officer's report, and I know what you're going to argue with me first, and go ahead.
Thank you, Your Honor. I did have a case here, I think last week or a week or so ago, but same issue. There doesn't appear to be a speed measuring device identified. Without that, cannot proceed.
Motion to suppress that, granted. Motion to dismiss, granted.
Thank you, Your Honor.
In fact, it'll be sent to the office and you can send a copy on to your client.
Okay, we will do that. Thank you.
Thank you for appearing. You take care. Have a good day.
All right, you too. Thank you. Bye.